Michael Dagger Margosian, I do have Jody Morris. Who's your attorney in the back? Who, Rhonda?
Yeah.
Okay. Okay, so Shan. Jody Morris, if you want to go ahead and start your video and your audio for me, please.
Okay.
All right, very good. All right, this is in the matter of the people of the state of Michigan versus Jody Lynn Morris. File number 23-216-37FH. Let me find you here. I have Dave McCready appearing on behalf of the people, and I have Michael Dagger Margosian appearing on behalf of the defendant, who is appearing via Zoom. Let me write all that in. Okay, so this is a date and time set for a pretrial. I do see an amended information as well as, nope, it was wrong file. So hold on. What's this? It was in the wrong file. I'm sorry. So let me do this. That goes back there. And so this is a date and time set for pretrial. What is going on here? Hold on. I swear. So I have a Rip or a David Sabino in my file. So that doesn't go. Wait, yes. It is involving Jody Morris. All right. So anyway, Michael Dagger Margosian, this is the date and time set for pretrial. How would you like to proceed today?
Your Honor, if I may have a moment with Miss Morris, please.
Sure. So I'm going to open a breakout room, and I am going to close all these breakout rooms. And give me just a second. All right. So Mr. Dagger Margosian and Miss Morris, I am going to open up a breakout room. You should get an invitation to join it and go ahead and join it. All right, so now we're back to the people of the state of Michigan versus DeAndre Morris. So Mr. Morris and Miss Underwood, how would you like to proceed today?
Yes, Your Honor. Thank you. Rhonda for Mr. Morris. Your Honor, we did receive back our criminal responsibility. And I've discussed that with Mr. Morris. The offer in this case is half charge, no subs, Your Honor. Mr. Morris is charged with 1 count of assault of a prison employee. I would be asking the court for a COBS to the low end of the guidelines on that, Your Honor. And with that provision, Mr. Morris would accept that offer, Your Honor.
Okay. Mr. Sneed?
People take no position and would defer to the court's discretion, Your Honor.
Okay, that's fine, Ms. Underwood. So, Mr. Morris, you understand the plea offer is plead as charged with no subs, which means it remains a 5-year felony and you would be sentenced to the low end of the guidelines. Do you understand that, Mr. Morris?
Yes, ma'am.
All right, would you like to take that plea offer?
Yes.
Okay, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. So, Mr. Morris, you can put your hand down. Thank you. You have heard the statement of your attorney and the prosecuting attorney. Is it your intention then to plead guilty to count 1, assault of a prison employee?
Yes, ma'am.
Are you satisfied with Miss Underwood as your attorney and the advice that she's given you?
Yes.
All right. Now, other than the agreement to sentence you to the low end of the guidelines, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Miss Underwood?
It is, Your Honor.
And Mr. Sneed?
Yes, Your Honor.
And Mr. Morris?
Yes.
Okay. So, sir, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at trial and ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Morris?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to a plea would be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No.
All right. So, Mr. Morris, how do you wish to plead to the charge that on or about August 4 of 2023 in Madison Township in the county of Lenawee, that you did commit the offense of assault of a prison employee? Guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to you to get you to plead guilty to this charge?
No.
All right. Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Miss Underwood? Can you
No,
go
Your
tell
Honor.
Quiet. Having a little party in the hall, so hold on, my bailiff's gonna go tell them to simmer down. All right, Mr. Sneed?
No, Your Honor. Thank you.
All right, so other than sentencing you to the low end of the guidelines, Mr. Morris, has your attorney promised you any other particular sentence or estimated what the rest of your sentence would be?
No.
Okay, and is it your own choice to plead guilty?
Yes.
All right, so Mr. Morris, on August 4 of 2023, were you at the Gus Harrison facility here in Lenawee County?
Yes.
All right,
I don't
and
know what
would you,
town.
okay, but it was in a township. It's called Madison Township. Would you agree that that would be true if I told you it was in Madison Township in the county of Lenawee?
I would agree that it took place in
Gus Harrison?
yeah.
Okay, and
Yeah.
if I were to tell you that's in Madison Township, would you agree with me?
Yes.
Okay, and that is located in Lenawee County. So at that time, you were lawfully in prison there, is that correct? You were an MDOC inmate?
Yes.
Okay, and was there a correction officer named Michael Guzman that was an employee there or custodian there?
Yes.
And did you assault him in some way? Did you spit on him, throw water on him? Tell me what you did.
I pushed it.
You pushed him? Okay. All right. All right.
People
Mr.
have
Sneed,
fun.
are you, okay. Has the court complied with MCR 6.302 B, C, and D? Miss Underwood
It has.
and Mr. Sneed?
Yes, thank you, Your Honor.
Okay, so let's break this down. Okay, okay, let me get that in. All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made an agreement regarding the sentence in this case. So there is a COBS. I'm going to refer this matter to the probation department for pre-sentence investigation. So Mr. Morris, where are you currently housed at?
Macomb, I don't know what county, I think it's Macomb County. Macomb
Yeah, it is.
Correctional
Okay.
Facility.
What was it, Mr. Morris?
It's at Macomb Correctional Facility.
Okay. Let me write the rest of this in. All right. So Mr. Morris, somebody from MDOC is going to reach out to you and they'll probably get you a packet to fill out and then they'll prepare a pre-sentence report. I will get a copy of that to Miss Underwood. Our public defenders are really good about doing their best to get in to meet with people, but sometimes it's harder to get into MDOC or the jails. So if she isn't able to meet with you that morning or that in advance of sentencing, she will be able to meet with you that morning, okay?
All right.
All right, and I'm going to set sentencing for August 16th. Are you here August 16th, Miss Underwood?
August 16th, yes,
Yes.
Your Honor.
All right, so I'm gonna set sentencing on August 16th at 8:15 in the morning. So, Mr. Morris, you do have a right to appear in person for sentencing, or you can do Zoom like you are today. Would you like to appear via Zoom or in person?
Appear in person.
You want to be in person? All right, I will mark that down. So, Mr. Sneed, we will need a writ on that.
Understood. Thanks, Judge.
Okay, all right. So, Mr. Morris, you are all set and someone will get a hold of you, all right?
All right, you have a nice day.
You too, Mr. Morris. Thank you.
All right, Ms. Underwood.
Judge,
Okay. Yes,
on that, the COBS was sentencing to the low end of the guidelines, correct?
yes, ma'am. Yeah,
That's all that was on that COBS?
yes.
Thank you.
Thank you. All right, Miss, let me see here. Somebody just popped in. Where's my breakout?
Your Honor, we're going to be dismissing Kyler Van Eps.
Okay, hold on. Give me 1 second. Let me figure out where. 1 second. All right, I closed the room. All right, so is he in the courtroom?
He is.
Okay, let me pull the file. All right, this is in the matter of the people of the state of Michigan versus Kyler Sean Van Eps, file number 23-21546FH. I have Attorney Sean Myers appearing on behalf of the defendant. And good morning. And I have Alexander Bayonetto appearing on behalf of the people. So for the record.
Yes, Your Honor. Mr. Van Eps did pay an agreed upon restitution amount through our diversion program. It is our intention to dismiss this case at this time. I do have 3 copies of that now, but I think we probably need to file that with the clerk.
Yep, it goes to the clerk's office. All right, so good job. And I wish you the best of luck, all right?
Thank you.
All right, I'll sign that upon presentation.
Thank you.
Thank you.
Thank you, Judge.
Okay, Mr. Dagger Margosian, I have, let me take care of yours. I'm gonna go back to Mr. Malaro, so hold on. Mr. Morris. All right, so Mr. Dagger Margosian, are you ready on Miss Morris?
Yes, Your Honor.
All right, we're back on the record in the matter of the people of the state of Michigan versus Jody Lynn Morris. So, Mr. Dagger Margosian, how would you like to proceed today?
Your Honor, good morning. Michael Dagger Margosian for Miss Morris. Today is the time and date set for the final pretrial in this matter. We have reached a resolution with the people. I don't know if the court has an amended information in the file, but I can let the court know what the plea and sentence agreement is.
Go ahead. I don't have a plea agreement form or that, so I know, but that's fine. They can file the amended information today.
Thank
All
you.
right, so what's the plea offer?
Your Honor, Ms. Morris is going to be pleading guilty to receiving and concealing stolen property, $200 to $1,000. It's a 1-year misdemeanor. In exchange for that, the original information would be dismissed. There's also an agreement for no upfront jail upon payment of restitution to be determined. We will be asking the court for a hearing for that. I think Mr. McCready is in agreement with that. We just need to finalize what that amount would be. And then, so that's really the plea and sentence agreement, but I do have an additional issue with the restitution once that's written down.
Okay, so if we're gonna have a restitution hearing, I'm gonna have to set sentencing out further than August. Any objection to that, Mr. McCready? Because I can't get a restitution hearing in before that.
No, as a matter of fact, Your Honor, the plea agreement reads that that we have no objection to adjourning sentencing to give the defendant time to come. The restitution we expect to be in the like $2,000 to $3,000, and so so we have no objection to moving that out as far as the court wants.
So could I do? Are we talking like December 5, December 6?
I think so. Yes.
Okay, Miss Adams, am I available for sentencing on either of those days?
Okay. December 6th is good.
All right. Okay, all right. Anything else on the record of the agreement?
Your Honor, nothing for the agreement, but the only thing I would address is that there is a co-defendant, David Sabino, as the court indicated in the file earlier. I believe that he would have pertinent information regarding this restitution, so I would be asking the people to procure him for that hearing.
I anticipated as much. I assume you're okay with him testifying remotely.
That's fine.
So he's scheduled to be here. I already have a writ for him on July 9th at 9 a.m. Do we want to keep that on? Miss Adams, is there any way we could get testimony from that day, or do you want another date with him, Mr. McCready?
Well, the only thing is, I mean, we're hustling to get him here, get all the paperwork, and I'm not 100% sure that we're going to be able to do that, but I'm open to.
I had a writ. That's why I have a writ in my file for him to be brought here. That's all.
Yes, we've been trying to process that writ since beginning of June, probably.
Okay. So I'm going to take the trial date off, and then you can just reschedule him as needed. Okay.
Yeah, that works.
All right. Anything else, Mr. Dagger-Margosian?
Nothing for the agreement, Your Honor. Thank you.
Mr. McCready?
Nothing else, Your Honor.
All right. So Miss Morris, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Can you state your full name for the record?
Jody Morris.
All right. So Miss Morris, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to an added count to receiving, concealing stolen property, 200 to 1,000, which carries a maximum penalty of up to 1 year in jail?
Yes.
Okay. Now, it doesn't mean you're going to go to jail. I'm just telling you what the maximum penalty could be. So obviously, if restitution is paid in full, that's not going to be an issue. Correct, Mr. Dagger-Margosian?
Correct, Your Honor.
All right. So are you satisfied with Mr. Dagger-Margosian as your attorney?
Yes.
Okay. Now, there has been a discussion on the record about a possible sentence, but other than the plea agreement that was placed on the record, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence, such as fines and costs and probation with the court. Is that correct, Mr. McCready?
Yes, it is, Your Honor. I just want to go back 1 second because I do think there was something. I just emailed the draft plea agreement to the court. I just like to read what it says because I'm not sure everything has been actually stated. We're agreeing to this added count to receiving and concealing 200 to 1,000, which is a 1 year misdemeanor, as the court has stated. But the agreement states no upfront jail if full restitution is paid at sentencing. Otherwise, the people are free to recommend a sentence of 1 year in jail. The people further agreed to allow sentencing to be adjourned until a restitution hearing can be held and the defendant has a reasonable time to obtain the determined restitution amount. And then also in exchange, we would dismiss count 1. So I don't know if all of that information was placed on the record.
Okay. Well, there was nothing about recommending of a sentence, but the prosecutor is always welcome to appear at sentencings and make recommendations that they'd like. So, all right, very good. Thank you. All right, so, all right, is that correct, Mr. Dagger-Margosian?
Yeah, of course, the people can always recommend whatever they want to recommend on a case.
Okay, all right, and is that correct as far as you're aware, Ms. Morris?
Yes.
All right, so ma'am, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. Mr. Malaro, do you want them to bring down one of your inmates?
Sure.
Who would you like first?
In there. I might as well give Mr. McKenzie.
All right. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand, Ms. Morris, if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Ms. Morris?
Yes.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. So do you have any questions about the rights that I've given to you, Ms. Morris?
No.
All right, so Ms. Morris, how do you plead to the charge? Let me get back to more information. How do you plead to the charge that on or about March 7 of 2022 in Riga Township in the county of Lenawee, that you did commit the offense of larceny, or I'm sorry, receiving and concealing stolen property with a value of 200 to 1,000. Is it the right thing? Yep. Guilty or not guilty?
Guilty.
All right. Has anyone made any threats or promises to you to induce you to plead guilty to this charge other than what was placed on the record?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during the hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is a prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. McCready?
No.
Mr. Dagger-Margosian?
No, Your Honor, thank you.
All right, has your attorney, other than the no upfront jail restitutions paid, has your attorney promised you any other particular sentence or estimated what probation fines and costs would be?
No.
All right, is it your own choice to plead guilty?
Yes.
All right, so, Ms. Morris, back on March 7th of 2022, were you in Riga Township in the county of Lenawee?
Your Honor, the facts of this case, there's
You can voir dire if you'd
yeah,
like,
it may
Mr.
make sense.
Dagger-Margosian.
That's okay. Ms. Morris, on as the court indicated, on March 7th of 2022, were you in the presence of David Sabino and Mickey Cryer?
Is that the day of the crime?
That's the day, yes.
Then yes.
Okay. And this was in Toledo, Ohio, correct?
Yes.
And those two individuals went to Riga Township that night, yes?
Yes.
Okay. And you were aware that they were going to that location?
No, I was not aware that they were going to that location.
Okay, at some point when they did go to that location, they brought items back from that location and brought it to your house back in.
Yes.
True, okay.
Yeah.
And you knew or had reason to know that those items that they brought back were stolen.
Yes.
And your intention of those items at that time was to not give them back or relinquish them. In other words, to keep it for personal property or not get it back to the owner. True?
Okay, say that one more time. I guess
Yeah.
I didn't understand it.
The property that was brought back to your house, the intention was to not get it back to that rightful owner. True?
Yes.
And for plea purposes, you'd agree that the property had a value between $200 and $1,000.
Yes.
Okay. I think I'm satisfied unless the people have any other questions.
Mr. McCready?
Satisfied.
All right. Has the court complied with MCR 6.302 B, C, and D? Mr. McCready?
Yes.
Mr. Dagger Margosian?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of her rights. She does have competent counsel. Other than the agreement that if restitution in full is paid by sentencing, there would be no upfront jail. This court has made no agreement regarding the possibility of a plea or possible sentence in this case, but the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Mr. Dagger Margosian, are you available August 16th for sentencing?
Well, I think we put it out to December.
Oh, I'm sorry. Yeah, I already did. So December 6th at 8:15 for sentencing. And ma'am, so because there's an agreement that restitution will be paid in full, I'm gonna make you come in person. Only because if you don't pay restitution by then, potentially there could be jail. So I'm going to ask that you appear in person for sentencing. I'm giving you a lot of time, so hopefully you'll be able to get that restitution paid, okay? Now, also, if you're making good faith payments and you're getting it down, we can always adjourn it out a little bit more, all right? So just work hard at it. So Ms. Teskey is from the Michigan Department of Corrections. So I'm gonna put you in a breakout room with her in just a moment. When you talk to her, she's gonna tell you about a packet you need to fill out and also schedule a date for you to come in and meet with the probation officer. Make sure you appear for those, be truthful about your background and the events that occurred. She'll prepare, or whoever is assigned will prepare a pre-sentence report. We will provide that to Mr. Dagger Margosian. Mr. Dagger Margosian will review that with you before sentencing. And then we will see you back on December 6th at 8:15. Mr. Dagger Margosian, if it's like October and no payment's been made, I may move her sentencing up. So it's important that she, be making monthly payments and showing an effort, okay?
Well, Your Honor.
Your Honor, this is a
Yes.
misdemeanor plea, so.
Oh, I'm
our
sorry,
office
it's Michael
will not be
McCarron.
doing-
Okay, I misspoke on that, Ms. Morris, but go ahead, Mr. Dagger Margosian.
So Judge, we just need I guess a date for the hearing, because I don't know if payment can be made until we finalize.
So
that.
you guys can reach out to Ms. Adams to get a date.
Okay.
Okay, so Ms. Morris, forget everything I said about MDOC. I'm still getting used to taking misdemeanor pleas up here. So not this Thursday, but next Thursday, I need you to come to the district court probation officer office on the first floor between 8 and 10. Can you do that?
Yes.
Okay, so it's first floor of the courthouse, district court probation, between 8 and 10 in the morning to meet with Mr. Michael McCarron, okay?
So is it the courtroom or the courthouse that I always went to when I came to Michigan?
Yes.
Yes,
Okay.
it's just like I'm on the third floor, but you'll be going to district court probation, okay?
Okay.
All right, thank you, sorry for that. All right,
Thank
you're all
you.
set, ma'am, thank you. Okay, so Ms. Morris, you're all set, you can disconnect.
Thank you.
All right, so, Mr. McKenzie and then Miss Underwood, I'll take your client next, okay? And I have no one in my waiting room. And Miss Adams, let's see, what do I have in jail? And then I don't have anything for you until 10:30. Miss Adams, could you call the jail and see if they could get Mr. Tate?
Okay.
All right, Mr. McKenzie, let me grab your file.
You do file this.
Files. You said 2 files? You said 2 files?
Yeah, there's a 23 4FH file, and then there's, well, it says September, but
Well, I only had the one for today, so are we taking a plea on both?
I do a plea on any.
We're not doing a plea on any?
No,
And the other one's set for a September pretrial?
that's what it says. I didn't.
What date, do you know?
September 4th.
Okay, sorry about that. Okay. So this is in the matter of the people of the state of Michigan versus Casey Michael McKenzie, file number 23-21324FH. I have Salvatore Malaro appearing on behalf of the defendant, and I have Dave McCready appearing on behalf of the prosecutor's office. This is the date and time. I just have the probation. No, this makes sense. Why is this just a violation of probation today?
Yeah, Judge, I just noticed that myself. We had prelim back in April that got bound upstairs. The transcripts probably due next week, I think, like middle of July, at which point we would be looking at motions to file.
So why don't we move this over to the September 4 date? Because that, if you get transcripts mid-July, that gives you 6 weeks to do your motions.
Well, I think Mr. McKenzie wants things to move a little faster. Is that correct?
Yeah, very.
Well,
shame that
it
one
takes-
was Trial in 108 days. I even have a prelim for 90 some days. I'm trying to
Okay.
argue that fact.
So you're waiting on your transcripts,
Yeah,
correct?
yeah.
So they come when they come. They have a time period that they're allowed to get those done by. And they're not gonna be done till July. And so you really, your attorneys probably advised you that you don't wanna proceed to get those transcripts.
So in order to file a motion for my prelim being pushed back 3 separate times due to the prosecutor filing bad writs or however, I think I just would.
Well, I can't argue the merits of that today because I gotta wait for motions and your attorney will file the motions.
So that means I can't have a trial in 108 days. That's correct?
Do you want me to set you for trial
Yes,
now?
Yes.
Your Honor,
Without yes, Ms. Teskey.
this is a whole separate probation violation from his new crimes. Like, this is a probation violation for
Yeah,
him being
so,
terminated
Mr.
from treatment. It has nothing to do with his new crimes.
So the only thing we're here for today is your probation violation. If you want to plead to your probation violation, I'll be more than happy to sentence you on that. On your probation violation, you're actually facing up to, let's see. So in your probation violation, it alleges that you absconded from the Eaton County RAP program. And that requires, is that right, Ms. Teskey?
No, he was terminated from the RAP program.
Right,
didn't
so
abscond,
that's
he
an
just-
automatic prison term. Is that correct, Ms. Teskey?
That is correct, Your Honor.
So the only thing I can do for you today, Mr. McKenzie, because we're only here on the violation of probation, your violation of probation has nothing to do with your new charges. So if you want to plead to your violation of probation from being terminated for getting into a dispute with another inmate in the program, I'd be more than happy to take your plea, but understand you're automatically have to go to prison on this.
Judge, when I spoke to Mr. McKenzie about that, he indicated he wanted it separate here.
Once, so, all right, I can set you a trial on this.
Yeah.
So Ms. Teskey, how long do you need for a trial to get your witnesses from Eaton County on this?
Your Honor, I would
Two-
say 2 weeks.
2 weeks? All right, Miss Adams, I need probably an hour for a violation of probation trial.
And Your Honor, for the record, I'm sure Mr. McKenzie would oppose any testimony by Zoom.
Oh.
Is that correct, Mr. McKenzie?
Yes.
Okay.
Can he do that, Your Honor?
Yep. So, I mean, yeah, it's just someone that works there. That's all you need is someone that works there, right? So, all right. So, Ms. Adams, I'm looking for about an hour.
Yeah.
Who are you going to call as?
I'll bring the book in, Judge. I'm not finding an hour.
Okay. And Mr. Malaro, your client would testify potentially. And then who else will you be calling as a witness?
And discuss that with him. Do you have some witnesses?
Yeah, her name's Tamia Dillard.
Oh, she runs the program.
Tamia?
Yeah.
Tamia Dillard, was he there?
No, she's a lady that runs it. They never took a statement or nothing from me.
Well, they don't have to. They don't have to.
Well, Judge, I've spoken to her in the past. I think she runs the program.
All right.
She does,
So,
and she was who I would be calling for a witness as well.
okay. Okay.
So you're definitely going to call her, Ms. Teskey?
Yes.
So I would not have to subpoena her
No.
then? All right. You okay with that?
Yeah.
All right.
Ms. Antoine, could I speak for a second?
No, I'm looking for a date. So you got to wait a minute.
Oh, yeah. I don't know what the fuck to say.
I'm sorry. What'd you say?
I told him I know what to say. He can't be my lawyer. I can't do this with
Then
him.
you are more than welcome to hire an attorney, but
I need somebody that's gonna do something.
so Mr. McKenzie, here's the deal. You ask for court-appointed attorney, you get a court-appointed
I got
attorney.
this back
Listen
off.
to me.
Now
All
listen.
right, you are held in contempt.
Oh my God,
So
you think
I'll bring you back next week. Thank you.
Give me 2 years of contempt, please. Could you?
You're actually looking at 5 years.
Oh, please don't.
Oh,
That's fucking
have a good
ugly, fat
day.
bitch.
Oh, like that's the worst thing I've ever been called. I've been called by,
Is that the worst thing you've ever done?
no. All right.
Sorry about that, Your Honor.
Not your fault, Mr. Malaro. All right,
All right.
so I'm going to
Ma'am.
set Mr.
Could you
Kenzie
get client
over.
control, please?
I'm sorry.
That is client control.
All right, so Mr. McKenzie hopefully will be in a better mood, so I can't set a trial date because now he's left the courtroom. So I'm gonna set his next pretrial over on this to, you're gone July 31?
I'm gone the 25th through the 31st.
All right, how about July 17th? Okay, do you want me to set the other file for pretrial?
Could we?
Yeah, so Miss Adams, I'm gonna set both of Mr. McKenzie's files over to July 17th. I don't have the file number. Is that all right, Miss Adams?
File number, Judge? I can give you.
Yeah, I have it,
Yes.
Judge. I have it.
Oh, she
This
has
is
it. And can you
Just for
do
a
this?
probation violation, correct?
No, I'm gonna set his other file for pretrial. Can you do it?
You want the number, Judge?
No, Miss Adams has it.
Okay.
All right. Can you do the step in order to adjourn this trial from
Yeah.
September to July 17th at 8:30? Okay. All right. So we'll give him a little thinking.
For the
time.
record, Judge, I'm down 30 pounds, so I'm trying to get up Mr. McKenzie's assessment.
Well, I think you look great. Okay. All right. So, how about Miss Traml, Mr. Coast?
Judge, she did test and she was negative. But I still have a problem with that because she's missed 6 consecutive. The first violation, she missed 3. So we have 9 missed tests. 2, when she comes to court, she knows when there's a good possibility she's going to be testing, but she was clean today.
All right. So, Mr. Malaro, my problem is the only reason she's allowed out of jail is because she's testing. If she's not testing and she's here on a methamphetamine charge, I have a real issue with that. She's set for sentencing next week, correct?
The 8th of August.
the 8th of August. So, you know, Mr. Malaro,
Here's what I can tell the judge, the court.
Me.
Sorry. You, the nice judge. Your Honor, she did what, 3 years of probation in
2
Jackson
years,
County
yeah.
for same offense. She was violated. The only reason, according to my talk to her probation officer, was discharge. We worked it out. The court, Mr. Coast now refreshes my memory. She was put on color. Miss Traml thought she didn't have to test at all. She has been testing. There was an issue with her, the expense of getting to Adrian to test. This is just a total mistake on her part. She called me this morning and said she just found out about this yesterday. So there's no, hey, I'm prepared to, you know, she's preparing not to test negative. Miss Traml's been fully engaged in this case. We've been trying to resolve this for quite a while now. Some of the, I think, problem was the prosecutor imparts gossip upon this court about her, who she associates with. Miss Traml's done everything she could to be in compliance with Jackson. And I understand that she's not in total compliance with this court, but I know that she's trying to do the best she can. She constantly tests negative when she is tested.
so Mr. Coast, have you reached out to her during this time period?
I have not, Judge, and I have not heard from her.
So Ms. Traml, you were aware you had to test because, listen to me.
Okay.
Because we came in on a contempt of court because you weren't testing.
Right.
Because
Okay, I'm sorry.
so we were here on the record. We changed it to accommodate you. So you were told you had to test on colors. And, you know, at this point, you know, you're still on colors. Mr. Coast's going to meet with you today, but if you miss one more drug test, I'm issuing a bench warrant for you and you will sit in jail to sentencing.
Okay.
Figure it out.
Okay, I just,
Say yes.
yes.
Okay, you figure it out.
Mhm.
So either, you know, you test in Jackson or you test here.
Okay.
But Mr. Coast will talk to you, but Mr. Coast, if she misses one drug test, I will issue a bench warrant. You are
Absolutely.
here on methamphetamine charges.
Mhm.
Those are serious charges.
Yes.
I let people out if they test,
Mhm.
okay? So
Okay.
last chance.
Okay, so I can test in Jackson.
Mr. Coast is gonna meet with you in the hallway and figure that out with you, okay? All right, so we'll see her back for sentencing. Mr. Coast, I'll send her out in the hallway to meet with you, all right?
Very good. Thank you, Judge.
What day she come back?
She's got sentencing.
Okay.
When's your sentencing?
August 8th.
August 8th. So I'll enter a plea of not guilty, but go ahead and sit in the hall, Mr. Coast will come in with you. All right,
Thank you, Judge.
thank you.
Judge, does this require a stipulation order?
No. 'Cause it's about, we did paperwork.
All right, okay.
I'm not guilty. And I'll set it over to August 8th at 8:15. Okay, all right, so I'm sorry, Mr. Dagger Margosian. Let me get, wait, where'd you find it?
Judge, do you have a Joshua Rowley either in court or on Zoom?
No, I'm sorry, I thought you had somebody in the breakout room, but I guess I did take care of your one, I guess. So I'm gonna call the case. So in the matter of the people of the state of Michigan versus Joshua Dexter Rowley. File number 23-21263FH. I have Michael Dagger Margosian appearing on behalf of Mr. Rowley. And I have Isaac Sneed appearing on behalf of the people. Says date and time set for a probation violation pretrial. He has failed to appear. Is he reporting to probation, Ms. Holly?
No, I haven't seen him, and he also has some pending things that he's not showing up for, I think, in district court as well.
All right,
I
so
haven't seen him
Mr.
all, since June. I don't know, sometime last month he reported early on.
Okay, Mr. Dagger Margosian.
I have nothing to add at this time, Your Honor.
All right, so I'm gonna issue a bench warrant for his arrest for failure to appear. a set bond in the amount of 25,000 cash. So, you ready? I want to come up. And I do have Miss Hennigan, your client, so just be a minute. I have Mackenzie Miller. Yes. Okay. All right. This is in the matter of the people of the state of Michigan versus Mackenzie Ricole Miller. 2 files 22-20935 FH 24-21725 FH. I have Rhonda Underwood appearing on behalf of Miss Miller, and I have Isaac Sneed appearing on behalf of the people. So we have probation violation hearing and a pretrial. So Ms. Underwood, how would you like to proceed today?
Thank you, Your Honor. Based on discussions I've had with Ms. Miller and with the prosecutor's office, Your Honor, Ms. Miller has a court date in district court on July 26th. I would like to adjourn these matters till the next available date after that date, Your Honor.
Are you available? How about August 7th?
That's fine.
What are these other charges? What are the new charges?
Oh, well, they're larceny charges downstairs. Yeah.
Ms. Miller, when we come back at some point, I'm gonna want an explanation on why you're getting in trouble. Is it?
These have been going on for a long time.
But is it a recovery issue, substance abuse? So I wanna, because it doesn't seem like this is typical for you. So, all right, so I'm gonna set this over to August 7th at 8:30 in the morning. You'll do the stip in order to adjourn the pretrial. Ms. Adams will do the renotice for the probation violation, and anything else?
Nothing else, Your Honor.
All right.
I would point out that since I've dealt with this, Ms. Miller has reported at all times early and alert court, and we've had no issues.
No, I haven't either with her. So.
Thank you.
All right, thank you. All right, Ms. Hennigan, I
was going to ask you, do we have Mr. Gonzalez Rodriguez from the MDO?
No, let me call that one because he is not here either. So in the matter of the people of the state of Michigan versus, let me find out. All right.
Okay, Rowley was all I had. I'm leaving.
No. I got so many files left. You can't. Oh, Sarah's watching. All right. 23-21565. Well, I don't even have a file for him. So, Ms. Adams, I don't know. All right. In the matter of the people of the state of Michigan versus Jonathan Gonzalez Rodriguez, file number 23-21565 FH. I have Rhonda Underwood appearing on behalf of Mr. Gonzalez Rodriguez, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial. For some reason, I don't have a file, but I also don't have him, so that's not as important. For whatever reason, MDOC has not presented him. I'm going to set this over to another date. Unfortunately, my next date is August 7th. So, Mr. Sneed, can you do the writ for that?
Yes, Judge.
And you'll do the stip in order to adjourn?
I will do that with Mr. Sneed's permission.
All right, Mr. Sneed, I'm sure will agree to that. And Mr. Sneed will do the writ. Well, he won't, but the person that does the writs will. And, all right, Ms. Underwood, is that all you have with me today?
Have you called Mr. Maps yet, Your Honor?
No, but I can. All right, in the matter of the people of the state of Michigan versus Terrence Jamal Maps, file number 2018-19019 FH. This is the date and time scheduled for
It's a show cause on a violation.
No, I'm looking for something. Okay. This is a show cause request and summons for probation violation. Mr. Maps has failed to report to the probation department upon release from the jail or at least report on June 10th. And his whereabouts are unknown. He was given notice to appear today. He's failed to do so. So I will issue a bench warrant for his arrest. And I will set bond in the amount of restitution, which is restitution. So I'm gonna set bond in the amount of 15,000 cash.
Thank you, Your Honor.
All right,
I
thank
will be
you.
back for Mr. Legore and Ms. Davis.
Okay, thank you. Okay, so hold on.
Come on.
Hold on, Mr. I'll be right with you, Mr. Tate. Give me 1 second.
No worries.
Okay, so grab Mr. Tate's file. Are you ready for next inmate?
Well, what am I, what?
Do you want another inmate?
Yeah, bring them all down.
All right, all of them?
Yeah.
If he wants to bring down
The remaining.
Sean Carter and Scott Rogers, he can, and we have Anthony Montmeyer, but probably the next one, just bring one of them down.
They're all well behaved.
They are well behaved.
Two of them, just one.
You can bring all of them or just one, it's up to him. We'll just keep them moving. All right, so this is in the matter of the people of the state of Michigan versus Harold Van Tate Jr., file number 24-21834FH. Mr. Tate, we have Isaac Sneed appearing on behalf of the prosecutor and Tamaris Hennigan appearing on behalf of Mr. Tate. So, Ms. Hennigan, how would you like to proceed on behalf of Mr. Tate?
Thank you, Your Honor. I know it's been a busy morning, but I did ask for a quick breakout with Mr. Tate so I could discuss this plea offer.
All right, so I'm gonna open up a breakout room somewhere. Okay, here we go. I'm gonna open a breakout room with Mr. Tate and Miss Hennigan. So go ahead. And while they're doing that, and they're bringing your clients down that don't body shame us, and we're gonna take a quick break.
I'm beyond body shaming.
I know.
That files for judge.
Of course. Okay, fine. Right.
Hey Sam, how are you?
Good. How are you?
Great. Totally.
You come in for the entertainment value, I'm sure.
Absolutely. Couldn't get any better. Jeez.
All right, fellas, let's have you have a seat right here.
You guys took the break from Mr. McKenzie.
Yeah.
We thought I had body bullshit. We are live on YouTube, guys. So just so-
Go home now.
One time, my wife was not in court is the one time I'm out here. So what do you think you're gonna want to do after you're done being transferred? Or would you just pick something else in a different field of the same stuff?
This job has shown.
Gonna have to be coming over here every time now, or?
The judge. I gotta be here, and you gotta be. I have to be here. I'll see you in a month. Hopefully, they fix your camera.
Hopefully less than a month. Less than a month would be better.
We'll see. I don't know.
Hey, Mary. Should I wear? 2 months.
Sure, Judge.
So happy.
I. Get tomorrow off.
Oh,
With a.
we're gonna change it, all right?
Thanks.
What about Friday, is courthouse closed or?
Court's open, I'll be here. At least in the morning. I gotta go meet an expert in Lansing.
Oh. Can't make it half what?
I can't afford.
All rise.
I can't afford it. I can't afford to have a meet me after.
Alright. So, Mr. Malaro, who would you like to start with?
Judge, we can do Mr. Rogers first.
All right, so Mr. Rogers. I have 2 files. All right, so this is in the matter of the people of the state of Michigan versus Scott Allen Rogers. We have 2 files, 24-21764FH and 24-21815FH. I have Salvatore Malaro appearing on behalf of Mr. Rogers. Who's my prosecutor? I just need someone to start their video. Isaac, Dave, Allison. Well, I'm just gonna take a stab at Isaac's. He's gonna be the, oh, no, Allison Arnold's prosecutor. So, Mr. Malaro, how would you like to proceed on behalf of Mr. Rogers today?
Judge, Mr. Rogers, we're trying to figure out a resolution, so I'd ask to adjourn this 2 weeks. I think I'll have an idea which direction we're going, and then.
So I can do, he's probably the last one I could set for July 17th. Is that okay?
That's fine.
All right. So I'm gonna set a pretrial for July 17 at 8:30 on both files. And you'll do the stipend order to adjourn.
Yes, Your Honor.
And Ms. Arnold, can he sign the stipend order, your name with permission?
Certainly, Judge.
Okay, all right. So, all right, so Ms. Rogers, thank you. We'll see you back then. All right, so next.
Mr. Montemayor.
Mr. Montemayor.
Right down the line.
All right, so let me pull up this file. All right, so this is in the matter of people of the state of Michigan versus Anthony Michael Montemayor, file number 23-21632FC, 24-21744FH. I have Isaac Sneed appearing on behalf of Mr. Montemayor, and I have Dave McCready appearing on behalf of the people. This is the date and time set for pretrial, both these files. What's the matter?
You say Mr. Sneed?
I said Mr. McCready, because that's whose picture is up.
Mr. Sneed appearing on behalf of my client.
Oh, I'm sorry. And no, it was Mr. McCready on behalf of the people, and then Mr. Malaro on behalf of Mr. Montemayor. So how would you like to proceed today?
So, Your Honor, there's 2 separate files that are sort of related. There's a lot of material. I'd ask to adjourn this out 30 days so I can meet with Mr. Montemayor, and if there's any motions we decide to file, we can get those filed.
August 14 at 8:30?
Sure, that's fine.
Okay, so we'll set these out for August 14 at 8:30 in the morning. You'll do the stipend order to adjourn?
Yes, Judge Elton.
Okay. And all right, so Mr. Montemayor, we'll see you back on that day, okay? Thank you. All right, so last but not least. Carter. So this is in the matter of the people of the state of Michigan versus Sean Raymond Carter, file number 23-21636 FC. I do show Salvatore Malaro appearing on behalf of Mr. Carter, but I do show Allison Arnold, prosecutor on this one.
Yes.
And Ms. Arnold is present via Zoom. So, Mr. Malaro, how would you like to proceed today?
Your Honor, we are close to resolution, but not quite there yet. I'd ask to adjourn this out perhaps 30 days. I think we might be able to get it worked out.
August 14th? Yeah. All right, so Mr. Carter, I'm going to set a pretrial for August 14th at 8:30 in the morning. Mr. Malaro, we will always accommodate you. So if you reach a resolution on any of these files and you want to bring them in on a day that's not a Wednesday, I'm more than happy to do that for a plea.
Oh, no.
Sorry, I thought I was on. I did put a plea expiration date of August 1st. So if Mr. Malaro wants to go past that date, he just needs to discuss it with me and I can do a new form.
Well, my next available pretrial, because I'm going to be gone, is August 14th. So can we extend it to that day?
Sure.
Okay. So agreement extended to August 14th.
Thank you, Judge.
You're welcome, Mr. Malaro. All right, you're all set, Mr. Carter. Thank you all, gentlemen. Have a good day. Okay, well.
4th of July.
Yeah.
Everybody.
Bye.
I thought they needed a break.
Yeah. I don't know. So is that it?
Well,
Your Honor,
you know,
just briefly. Just briefly.
Yes.
Your Honor,
Yes.
did you call Ernest Conway?
No.
I have that on my schedule this morning.
I don't call him until I have you. So I can call him now, but
yep.
I think I'm done, Judge, but I'll stick around for a few.
So in the matter of Denise Kudiker versus Ernest Conway, file number 24-51649. PP, this is the date and time set for an order to show cause for violation of a no. Says the date and time set for an order to show cause. No. 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 For a show cause pretrial, gave them a PR bond, it looks like, and they were ordered to appear today. And I'm looking for a notice in the file. Looking. Ms. Adams, do I have a notice for today's hearing? Because it's not in my file.
Let me see.
Which doesn't mean it's not across the hall. It's not. Oh, nope, I found one. It's on the pretrial release order, which he would have received from the Lenawee County Jail. He's failed to appear. Miss Underwood, do you have your client somewhere?
No, I do not, Your Honor.
All right, so I'm going to issue a bench warrant. Wonder, I'm supposed to work with Mr. Coast. 4732. Start taking back in. This is awesome with one judge. Goes really fast.
Yeah.
Maybe I have to tell Judge O'Saber, you can't work on Wednesdays.
I reached the phone of Darren.
Darren's not there. So I'm going to issue a bench warrant for his arrest. I will set bond in the amount of 2,000 cash. So 2,000 cash. Okay, let me double check. Do you hear Chick-fil-A is gonna be in Adrian today at 4 o'clock? They have a food truck.
Oh, okay.
Yep, it's gonna be at O'Reilly's or whatever on South Main. Casey McKenzie, I guess he's done. Mr. Montemire's done. It looks like the only remaining thing I have on my docket, I have a 10:30 motion on Mr. Legore with you, Miss Underwood. So I'll see you at 10:30.
Yep.
All right. So we are on the record in the matter of the people of the state of Michigan versus Harold Tate, file number 24-21834FH. I have Isaac Sneed appearing on behalf of the people, and I have Tamaris Hennigan appearing on behalf of Mr. Tate. We did have a bench conference earlier, and Miss Hennigan, have you had plenty of time to speak with Mr. Tate?
I have, Your Honor. Thank you.
All right. So how would you like to proceed with Mr. Tate today?
Your Honor, we've been made a plea offer by the prosecutor, and my client would like to take advantage of that offer today.
All right. And what is the plea offer?
My client was offered to plead to count 1 with the drug sup, no habitual offender, with a Killebrew to 24 months minimum in MDOC. And no objection to that running concurrent with the sentence he is now serving for Hillsdale County.
Okay. So Ms. Teskey, Mr. Tate is serving a jail term on a case from Hillsdale County. And Mr. Tate, your probation's been terminated on that file, right?
That's right.
All right, and so Ms. Teskey, we did have a conversation with Ms. Holly earlier, and we believe that, and Mr. State and Ms. Hennigan, that any sentence I give him would run concurrent to that jail term he's serving for Hillsdale County.
That's correct, Your Honor.
Okay, good. All right.
The only way that it would be mandatory consecutive is if he was serving a current parole or prison sentence.
Yep. Yep. We just want to make sure. Okay, so he's pleading guilty to count 1 with a drug sub. So the maximum penalty would be 20 years. Count 2, count 3 would be dismissed, as well as the habitual offender 4th offense notice. I'm laughing because I need fingerprints on him. Yeah, he's at our Lenawee County Jail. So Miss Adams, could we please call the jail and get them printed? Or maybe they did and I just don't have the TCN number back. All right, so Mr. Tate, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
That's ma'am.
Okay, so you can put your hand down. So Mr. Tate, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, controlled substance, possession of methamphetamine with a subsequent offense notice, which doubles the penalty to a maximum penalty of up to 20 years in prison, with the understanding that your minimum sentence would be 24 months. So I will sentence you to 24 months, but your tail will be 20 years. So as long as everything's good in prison, you'll get out after 24 months. So is that your understanding of the plea?
Yes, ma'am.
And is it your intention to plead guilty to that today?
Yes, ma'am.
Okay, are you satisfied with Ms. Hennigan as your attorney and the advice that she's given you?
Yes, ma'am.
Okay, now, other than that agreement, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, Your Honor.
Ms. Hennigan?
Yes, Your Honor.
And Mr. Tate, as far as you're aware, is that correct?
Yes.
All right, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. So, Mr. Tate, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Tate?
Yes, ma'am.
Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes, ma'am.
All right. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you, Mr. Tate?
No, ma'am.
All right. So how do you wish to plead to the charge that on or about December 24th of 2023 in the city of Adrian in the county of Lenawee, that you did commit the offense of controlled substance possession of methamphetamine, guilty or not guilty?
Guilty.
All right. And how do you plead to the second offense notice that you had a prior conviction for possession less than 25 grams on or about December 1 of 2022? Guilty?
Yes, guilty.
Oh, yeah. Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, ma'am.
As any, do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes, ma'am.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Steen?
No, Your Honor.
Ms. Hennigan?
No, Your Honor.
All right, so other than the sentence that was placed on the record, Mr. Tate, has your attorney promised you any other particular sentence or estimated any other parts of your sentence?
No, ma'am.
All right. Is it your own choice to plead guilty?
Yes, ma'am.
All right, so Mr. Tate, back on December 24th of 2023, were you in the city of Adrian in the county of Lenawee?
Yes, ma'am.
And at that time, did you have in your possession methamphetamine?
Yes, ma'am.
And you knew it was methamphetamine?
Yes, ma'am.
And you had no legal right to possess it, is that correct?
No, ma'am.
Okay, and then you have a previous conviction of probably possession of cocaine less than 25 grams back on December 1 of 2022, is that correct?
Yes, ma'am.
All right. Has anyone, let's see. We'll go back. Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor.
Ms. Hennigan?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. The court has had a Cobb's agreement reached with the parties regarding sentencing in this matter. So I'm going to refer this to the probation department for a pre-sentence investigation. And Mr. Tate, I'm going to set sentencing for August 16th at 8:15. Are you available that day, Ms. Hennigan?
Yes, Your Honor.
All right, so August 16 at 8:15 in the morning. Mr. Tate, you do have a right to be present in person for sentencing, or you can appear via Zoom. The choice is yours. So how would you like to appear for sentencing, Zoom or in person?
It could be Zoom, but can I just,
Okay.
when I get sentenced, can I get immediately transferred to MDLC?
Yeah, you're at our jail right now, right?
Yes.
Yeah, our jail's pretty happy about moving inmates, so they
Okay.
usually ride you out that day. Okay.
All right.
And I understand your eagerness. Okay, so Mr. Tate, someone from MDOC is going to come meet with you. They're going to ask you about your background and the events that occurred, and they'll prepare a pre-sentence report. We'll provide that to Ms. Hennigan. Ms. Hennigan will review that with you before sentencing, and then we'll see you back on August 16th, okay?
All right, thank you.
All right, thank you, Mr. Tate. You have a good day.
You too.
Thank you, Your Honor.
Thank you. All right, that's our docket. I'll see, I have a motion at 10:30, so I'll see you guys back on that.